Hello, my name is Christina Morgan. I am the Behavioral Health Unit Liaison Manager for the Wayne County Probate Court and also a consultant with the Wayne State University School of Social Work, Center for Behavioral Health and Justice. Today, I will go over some forms that are normally causing difficulty for individuals who complete them, and to just inform you of some tips and to make it a little bit easier to complete the forms for the probate court in your county. The forms that we will discuss today will be the PCM 236, demand for hearing, the PCM 230, notification of noncompliance and request to modify order, as well as the PCM 218, petition for second mental health treatment, and also the PCM 218A, petition for continuing mental health treatment. We will start with the PCM 236 demand for hearing. The reason for the demand for hearing is to notify the court that an individual has been non-adherent to the deferral that they agreed to, and to request that a hearing be scheduled in order to have the individual come before the court and speak to the judge as to why they have not complied with treatment. Or it is an opportunity for the individual who had deferred to demand a court hearing to inform the judge that the treatment that was ordered was not being carried out by the provider. Here is the PCM 236 demand for hearing. At the top of the form here, you will put the case number for the individual's mental health case in your county. Next, you will complete the top line, which indicates the individual's name. You will then select the most appropriate box, 1, 2, or 3. For box number 1, that would be if the individual who had been ordered or deferred to treatment is demanding the court hearing. Number 2 would be completed either by a hospital or outpatient provider who is requesting a hearing for an individual who has not adhered to their deferral, or if the individual has informed either the hospital director or designee or the outpatient provider that they want a hearing. Number 3 indicates that 14 days before, but no later than 7 days before the expiration of the deferral, if the CMH provider, which would be the outpatient provider, believes that the individual needs continued treatment, the outpatient provider or CMH may file a demand for hearing if the individual does not agree or the individual is no longer found suitable for community treatment. So box number 3 would be completed if 2 weeks before the deferral ends, the outpatient provider believes that the individual continues to need treatment and treatment in the community is no longer necessary. Either the first box or the second box can be completed. The first box again indicates that the individual continues to require treatment, but does not believe that he or she continues to need treatment. The second box here would be selected if the individual continues to require treatment, but is not found suitable for voluntary treatment and a hearing is being demanded. This simply means that the individual needs to be hospitalized again and does not believe that they need to. Box number 4 would be completed 14 days before, but no later than 7 days before the expiration of the deferral. If the hospital believes that the individual needs continued hospitalization, the hospital may file a demand for hearing if the individual does not agree or if the individual is found not to be suitable for voluntary admission. Again, this box would be checked if the individual is already hospitalized and they have deferred to treatment, and the hospital provider believes that either the first box, which is they will not agree to sign into the hospital voluntarily after the deferral is set to expire, or the second box would be checked if the individual is not suitable for voluntary admission, meaning the individual needs to be petitioned or repetitioned, and the hospital is demanding a court hearing. Box number 5 would be selected if the individual requires hospitalization pending the hearing and it is necessary for the individual to be transported. Number 5 would normally be checked and correspond to box number 2 or box number 3. So this is for an individual that is in the community, has deferred to treatment, but needs to be hospitalized pending the demand hearing because the individual needs immediate treatment. Number 6 corresponds to number 5 and putting the location of the individual so that he or she can be picked up for treatment. Of course, as with all forms, you would date, sign, and indicate your name, address, city, state, and zip code, and forward the form to the probate court. This is just a reminder that the original deferral specifies the length of the deferral. So the dates that are requested on line 3 and line 4 would be found on the original deferral. What can be deferred to is up to 60 days of hospitalization only, up to 60 days of hospitalization and the remaining time up to 180 days of outpatient treatment, or up to 180 days of outpatient treatment only. The original deferral will have the information to advise of when the deferral expires, which would be listed on line 3 or line 4. We will now complete the PCM 230 notification of noncompliance and request for a modified order. The purpose of the notification of noncompliance and request for modified order form is to either advise the court of an individual's noncompliance and or ask that the individual be ordered back to the hospital. Also, the form can be used to modify a mental health treatment order if it is not deemed appropriate for the individual. As you can see at the top, if you are requesting a change to the original order, that box would be checked next to request for modified order. If you are only asking for, or if you are only notifying the court of noncompliance, that box will not be checked. To begin, you will complete the information at the top with the respondent's case number. Then you will fill out the first line with the respondent's name. Section 1, you will indicate who you are that is asking for the order to either be modified or to notify the court of noncompliance. You are either an agency, which is the outpatient provider, the mental health professional who is supervising the individual's assisted outpatient treatment plan. This can be an independent psychiatrist or psychologist if the individual is not receiving other services such as case management or therapy. The individual themselves or the respondent can also complete this form requesting a change to their order, and that box would be selected. Other could represent the hospital or some other individual who has noticed noncompliance on the behalf of the respondent. Section 2 reads, the individual who is the subject of this notification was ordered to undergo a program of assisted outpatient treatment or combined hospitalization and assisted outpatient treatment. It is important to stop here and note that the order for mental health treatment can only be modified if it originated as an order for assisted outpatient treatment only, or an order for combined hospitalization and assisted outpatient treatment. Again, this form cannot be used if an individual was only ordered to hospitalization. Next, there are 3 selections under Section 2. One box should be checked in correspondence to notifying the court of noncompliance. The first box indicates, box A, that the assisted outpatient treatment has not been or will not be sufficient to prevent the individual from inflicting harm or injuries to self or others. Box A would be checked if the individual was ordered to assisted outpatient treatment only, and the person completing the form is notifying the court that the person has been non-compliant with treatment and the program or the treatment order is not sufficient. Box B reads, the individual is not complying with the order for assisted outpatient treatment or combined hospitalization and assisted outpatient treatment. This would be to notify the court that the individual is not compliant and they are either on an assisted outpatient treatment only order or a combined treatment order. Box C indicates pretty much the same thing as box A, except it is just indicating that the assisted outpatient treatment program is not appropriate. But as you see, it does not list that the individual will harm or injure himself or herself or others. One of these boxes needs to be checked in Section 2 when notifying the court of noncompliance or requesting a modification to the order. This is just stating to the court what is happening with the individual and why the request to modify or the notification of noncompliance is being submitted. Box 3 is if the individual needs to be rehospitalized and is on a combined order, you would indicate how many days the individual spent in the hospital when ordered, and then you are asking in this line that the individual be hospitalized immediately because they need treatment. Box 4 or Section 4, 4A needs to be completed. It is your personal observation as the petitioner as to what is happening with the respondent and what you have observed and the reason why you are submitting this form to the court. Box B is optional, and it is to substantiate any claims or behaviors that have been witnessed by someone other than the person completing this form. Box 5 would be for an individual who has either a combined order or an order for assisted outpatient treatment only, and the provider believes that the individual needs to be returned to the hospital. This would coincide or correspond with box number 3 being selected. Box number 5 would also be selected if the provider psychiatrist has deemed the individual non-compliant with treatment and needing to return to the hospital. Box 6 in Section 6 should only be completed if you are requesting that the court modify its mental health treatment order for the respondent. The following options are available. The first thing that you must do is select 6, and then you will indicate if the individual was on an assisted outpatient treatment only order or if the individual was on a combined treatment order. Next, you would advise as to what you would like to happen from the court or what you would like the court to do. Box A would be you want the individual to undergo another assisted outpatient treatment program. That means that you want the program changed or modified in some way. That could be a modification to the amount of days that the person receives treatment and or the services that the person is ordered to receive. The next box, B, would be to suggest or recommend that the respondent be returned to the hospital and then be placed back out into the community on a combined assisted outpatient treatment order. And it would specify the number of days that the individual needs to be rehospitalized for here at this section. The last option would be option C, which is that the individual should be transported to the hospital by a peace officer if the individual refuses to go on their own. Again, you will date the form, sign it, indicate your title and the agency that you represent, as well as your address information. We are now going to discuss the PCM 218 Petition for Second Mental Health Treatment Order. It should be noted for the petition for second mental health treatment order that there has to be an existing initial order for mental health treatment, which is the PCM 214. This petition for a second mental health treatment order needs to be filed with the probate court 14 days before the expiration of the initial order. If the initial order is set to expire and this form has not been submitted 14 days prior to the expiration, then this petition should not be used. The correct petition to use at that point would be the PCM 201, the initial petition for mental health treatment. To begin with this form, there is only one clinical certificate that is necessary. There will not be a need for two clinical certificates, regardless of what is being asked for. To begin completing the form, you would indicate the case number for the respondent. You would put the respondent's name in the top line here. You would then indicate in section 1 your name and your role with this individual. Are you either a mental health treatment provider or are you a hospital? You would select the box here that you are authorized representative of a hospital or mental health professional that is supervising the current order for mental health treatment. You would indicate again your name here and also the name of the hospital or agency. So if the individual is still hospitalized, you would put the name of the hospital here. If the individual is out in the community, you would indicate the name of the outpatient provider here. Next, number 2, you would either indicate that the individual is residing at some address in the community or that the individual is hospitalized at what hospital and their address. In section 3, you would indicate the date that the initial order for mental health treatment expires. Again, this form should only be completed if an initial order is on file with the probate court, and as a treatment provider, you are extending the course of treatment for the respondent. For section 4, you would indicate what it is you're asking for the individual. If the individual is currently in the hospital and you are asking for more time, you would select the first box, hospitalization for not more than 90 days. If the individual is in the hospital but is thought to be getting out of the hospital before the 90 days expires, you have the option of asking for combined hospitalization and assisted outpatient treatment, both to total no more than 90 days. So they can have any combination of time in the hospital and the remaining time as assisted outpatient treatment, not to exceed 90 days. Lastly, this box would be selected if you are an outpatient provider and you are asking to extend treatment for someone who is already on an order. It does not matter if they were previously on a combined treatment order. If you are not asking for them to be rehospitalized, you will select the third box indicating that you are only asking for assisted outpatient treatment for not more than 90 days. Box 5 indicates that you agree that the individual is likely to refuse treatment on a voluntary basis when the order expires. In section 6, you would select which criteria the individual meets that is warranting that a second order be granted by the probate court. You can indicate 1, 2, or 3 of these criteria, but at least one box does need to be selected in section 6. For section 7, you as the petitioner would want to indicate what you have observed yourself regarding this individual that warrants a second order for mental health treatment. Box B is optional, and if there is a witness who can substantiate the claims that you listed in section A, you can list that information as well as the witness's information on this line here. Also, do not forget at the top of the second page to put the respondent's case number, just in case the forms get put out of place or are missing. They can be located by having all of the correct information. Section 8 is where the petitioner indicates the diagnoses of the individual. Number 9 is where the petitioner indicates what course of treatment was provided under the initial order for mental health treatment and the results of that treatment program. Section 10 indicates that the present treatment is or is not adequate and appropriate to the individual's condition. So you would select whether or not the present course of treatment prior to the filing of this petition is adequate. Next, you would indicate if the individual is or is not motivated to participate in the treatment program and the estimate of further time necessary to provide the required treatment for this person. So you would indicate again whether or not the person is motivated while they are completing their treatment and what you believe as the petitioner is the time that will be needed in order to get the individual the treatment that they need. In this section as well, you will indicate the modifications that you will be making to the current treatment program in order to get the individual the treatment that they need with the 90 days that you are requesting. If you do not need to make any changes to the program that they are already on, you would just indicate none in this section. Section 11 is exceptionally important because you want to make sure that any individuals who are specified as interested parties for the respondent are added to this section. This would be for anyone who was not listed as an interested party on the initial petition for mental health treatment. If you do not have access to that form, it is okay. You can simply list the interested parties who you believe should be notified, and the court will ensure that they are entered into the party record. Box number 12 is simply line number 12, is simply an agreement that a clinical certificate has been executed and is attached. The clinical cert does need to be completed by a psychiatrist. Number 13, again, requests what it is that the petitioner is asking for. Either hospitalization for not more than 90 days, combined mental health treatment, which is some portion of the treatment will occur as hospitalization, and the rest of the treatment will occur in the community as assisted outpatient treatment for not more than 90 days total for both treatment modalities. Or lastly, that you are just requesting assisted outpatient treatment for not more than 90 days. You would date the form, sign the form, and list your address and telephone number in this section and forward to the probate court. This is the PCM 218A, Petition for Continuing Mental Health Treatment Order. The petition for continuing mental health treatment order should be completed prior to the expiration of a second order for mental health treatment or a continuing order for mental health treatment. This form does need to be filed 14 days prior to the expiration of either of those orders. If this form is not completed 14 days prior to their expiration, you must complete a PCM 201 initial petition for mental health treatment instead. To begin completing this form, enter the case number of the respondent in this box here, as well as the respondent's name at this section. In section 1, you will indicate your name and select the box stating that you are the authorized representative of the agency or you are a mental health professional that is supervising the individual's assisted outpatient treatment program. This is for any individual who has a combined treatment order or assisted outpatient treatment order. Section 1 would be completed there. You will indicate your name as well as the name of your agency or hospital. Section 2, the individual is currently either residing at some location within the community, and you would enter that information on these lines and select the first box. There is also space to indicate the telephone number of the respondent. Or you would select the second box stating that the individual is hospitalized and indicate the hospital's name, address, and telephone number here. Section 3 alerts the probate court as to whether the individual is currently on a second order for mental health treatment or a continuing order for mental health treatment and the date that that expires. That information can be found on the second order for mental health treatment or the continuing order for mental health treatment, whichever is applicable to this respondent. Section 4 indicates what it is that the person completing this form is asking for the respondent. There are several choices that can be selected, but there is only one selection made. The selection can be for either hospitalization for not more than 1 year. This request would be made by a hospital. For continuing hospitalization for a period of 1 year, which means that you are asking specifically for 1 year. That selection would be the second selection. The third selection indicates that the individual will need combined treatment. Some portion of a year would be in the hospital, and the remainder of the time, up to 1 year, would be in an assisted outpatient treatment program. Lastly, the selection here indicates assisted outpatient treatment for not more than 1 year. Number 5 is just the agreement that the individual is likely to refuse treatment on a voluntary basis when their current order expires, and that is the basis for completing this form. In section 6, the criteria for the individual that is met under the Michigan Mental Health Code would be selected in either box A, B, or C, or all 3 of the boxes, or 2 of the boxes, but at least 1 box does need to be selected. On the second page, you would put the respondent's case number again to ensure that the forms are kept together and that everything has been completed. Section 7A indicates what it is that the petitioner has witnessed and any behaviors of the respondent that is the basis for a continuing order for mental health treatment. Section B should be completed if there are witnesses who can substantiate what was listed in Section A. The witnesses' information or statements can be presented in this section, and their name, address, and telephone number should also be included. Section 8 indicates the diagnosis for the individual. Section 9 indicates the results of the current mental health treatment program that the respondent is participating in. Section 10 indicates that the present treatment is or is not adequate and appropriate for the individual's condition. And it also indicates that the individual is or is not motivated to participate in the treatment program, and provides an estimate or a time frame necessary to provide the treatment that is required for the individual. If there are any modifications to the existing treatment plan, that information should be listed in this section. And if there are no modifications that should be listed, then the petitioner can simply write none. Section 11 should list the interested parties of the individual in this section if they were not already listed on the initial petition for mental health treatment or the petition for a second mental health treatment order. If you do not have access to those original petitions, you can put the information for the interested party here so that the court can make sure that those are entered into the respondent's party records. Section 12 is an agreement that a clinical certificate that has been signed by a psychiatrist is attached to this petition and is being forwarded to the probate court. Section 13, again, specifies what it is that is being asked for the respondent. Either hospitalization for not more than 1 year, continuing hospitalization for not more than 1 year. This is for an individual who is already on a continuing order. Combined hospitalization and assisted outpatient treatment for not more than 1 year. And lastly, assisted outpatient treatment for not more than 1 year. Only one box should be selected in section 13. The form should then be dated and signed, and the address for the petitioner and telephone number should be listed, and this form, along with the clinical certificate, should be forwarded to the probate court. Thank you so much for your time today in watching the trainings on how to complete the PCM 236, demand for hearing, the PCM 230, notification of noncompliance and request to modify order, as well as the PCM 218, petition for a second order for mental health treatment, and the PCM 218A, petition for continuing mental health treatment order. Thank you.